Welcome back to the Wealth Actually podcast. I'm Fraser Rice. We're going to talk a little bit about the estate settlement process, and it's extremely important, and it can be scary for some people. It really is where the rubber meets the road in the estate planning process. This is when wills are proven, trusts go into effect, and assets get distributed to the next generation. I have Joel SCHOENMEYER on, and he's going to talk about the ins and outs of the process with us. Welcome aboard, Joel.
Thank you so much for having me.
For a little background, tell us a little bit how you got into the industry and what you're up to now.
I graduated from law school, University of Michigan in 1996. Spent about the first 15 years of my life as a trust and estates attorney. I was at a few different law firms, including Sidley Austin, back when they had a trust and estates group, which they no longer do. And then I was a solo practitioner for more than a decade. In about 12 years ago, I made the transition to working for financial institutions. And I've now am at the third financial institution of my career, was in the legal department in the trust counsel group at Northern Trust. Was also a senior trust advisor at Northern Trust. We moved over to BMO, what was then known as BMO Harris, as the national head of estate settlement. So very related to what we're talking about today, and was also a senior wealth strategist with BMO Family Office, which is their ultra high net worth group. I am now in charge of the family wealth group at Fifth Third, which is an offering that we have for wealthy clients and their families.
Cool. That's basically what I do in terms of helping to manage the train schedule that a lot of families go through in terms of executing and making sure things happen when they're supposed to. So let's start at the very beginning. What happens legally when someone passes away?
That's a great question. And we probably need to start with a little terminology. So the overarching term that I'll use is estate settlement. And that's really kind of the wrapping up of a deceased person's affairs. And that really involves not only legal issues, but also some non-legal issues. And I'll get to the legal part in just a minute. Those jobs are handled by what's known as an executor. And that's really the person that you've designated in your will to handle your affairs. And if you don't have a will, it's a little like when they say on Law and Order, if you don't have a lawyer, one will be appointed for you. If you have not named an executor, an administrator will be appointed for you. And that's somebody typically who would petition the court like a family member or a friend. So we've got the estate settlement process broadly. And that includes a lot of different things. Like I said, it's some legal things, but it's also a lot of just financial and kind of walking around and collecting assets, inventorying assets. It's figuring out what the decedent had in terms of debts and expenses. It's taking a look at that inventory and figuring out, okay, what are the tax situations? I've encountered situations where I step in on an estate when we find out that the decedent hadn't paid income taxes for 15 years. Or had never paid income taxes, was one situation that we encountered. You also have to be thinking about estate taxes, which again, I'll get to. That's for people who have significant wealth. So you're really focused on the assets, focused on those debts and expenses, and then focused on distributing what remains after the debts and expenses and taxes are paid. And that distribution is either made in accordance with your estate plan, your will or trust, if you have one, or if you don't have one, in accordance with state law, what we typically call intestacy. That's dying without a valid will. And so within that estate settlement, there is this little part of it that is called probate. And I think people, to the extent that they know what probate is, probably have a bad opinion of it. They probably think of it as a lengthy and costly court proceeding, and it can be, but it really is a court supervision of the process to make sure that that executor or that administrator is doing their job correctly. Obviously, there's always a risk that somebody's going to, take your assets and run off to Tahiti. And the court, the probate judge, is going to make sure that that is not done and make sure that everyone has the appropriate notice, make sure that everything's done correctly. And in my career, to go back to what we were talking about in terms of my background, I spent time drafting wills and trusts, but I was always really passionate about helping with probate, helping with estate settlement and dealing with those probate issues, including litigation, where something goes wrong typically, and parties are fighting over decedent assets and the like.
So we talked a little bit about the messy situations that can pop up here. Why is that important? And then I guess sort of a lead into the idea of what should people be thinking about as they start this process around figuring out how this estate settlement process is going to work.
Sure, sure. I'll say like throughout my career, and especially when I did estate planning, I would encounter these clients or potential clients who would say, you know what, I don't care. When I die, I'm gone. When I shuffle off this mortal coil, it's somebody else's problem. And I always push back on that a little bit because I think you dig deeper, and it's something that I think sometimes people say it for other reasons, maybe psychologically, they just don't want to think about death. But most people don't want to cause problems for their loved ones. And I try to explain it in that context. I say, you know what? Your family loves you, your friends love you. It's difficult enough to deal with the death of a parent or a spouse or a sibling without having to try to figure out what they owned, try to wrap up their affairs, try to sell their home if that's what's needed. So, I think it's important to really, it's kind of an act of care for the people around you, even if you don't care about it. But there's also, I almost think of them as a flip side, a positive aspect, which is you've worked hard to make your money and you have family, friends, charitable causes, things that you care about after you pass away. Why would you not want to make sure that the people you love get what you want them to receive and get it in the way that you want them to receive? So that might be a trust. It might be setting things up to make sure that the things you care about, the people that you care about thrive. Maybe that's setting up, a charitable foundation at your death. Maybe it's setting up a scholarship fund for local, high school students. Maybe it's, leaving money to your children and grandchildren so that they can pursue whatever they want to pursue. Those things are really important. And so when I talk to people about estate planning and about estate settlement, I try to focus on those things. And frankly, some of those people who start out saying, I don't really care, they get a little more interested at that point.
I'm dealing with it on a couple of situations now where the planning and sort of the process were, I would say, well thought out way back in the day. But then we're going to talk about this shortly. You've got people working together where all of a sudden there's some vagueness in the estate plan, and that leads to conflict and sort of orneriness around decision making. Conflict is expensive and annoying and something that I think is really not a great situation for someone to leave to somebody else. So as we think about this, and we sort of alluded to the estate and getting people ready for it, what are the big mistakes that you see vis-a-vis assets? And how do you get people to think about getting things in place for this time when they're no longer here?
The main thing that I see, and this is something that is arisen more in recent years. And I mentioned before, everybody hates the idea of probate, whether they know what it is or not. They know it's something to be avoided. And so what we've seen is, a long time ago, people would only own assets in their own name, and all of those assets would flow through this probate process. Well, we now have different mechanisms, whether it's a trust, whether it's joint ownership, whether it is now, and this is something that I've seen really arise over the past, 10 or 20 years, is allowing you to name a beneficiary on lots and lots of different assets, a payable on death account. I think now in a lot of states, you can actually name a beneficiary to inherit your real estate immediately upon your death.
I just did one of those in Illinois. It's becoming much more popular.
Yes, it is. And in some ways that's really good. But what it means is people are not paying attention holistically to how their plan works. And I can kind of give you an idea of an example of something I dealt with back when I was practicing law. Was I had an estate, we had a will. The will, the decedent gives her a home to her boyfriend. But the problem is that the decedent already owned that home in joint tenancy with her sister. And so now you've got a court dispute. Now you've got a very upset sister. And you're wondering, why is it that we have two documents that are really diametrically opposed? We've got this document where she, tries to give it away under her will, but she's already owns it in joint tenancy with somebody who automatically, by operation of law, inherits it upon her death. that's the kind of mess that we're talking about. The other thing that I mentioned holistic, is people really don't look at each of their assets, figure out where those assets are going, and figure out is that really reflective of the plan of what I want to have happen. Sometimes I see that in terms of, I have an asset with X value, and I think to myself, yes, I'd like my sister or my cousin to receive $1 million, but let's say that's in Nvidia stock or something like that. So now it's 10 million or $20 million. Again, now it's thrown your estate plan out of whack. And so that's what I mean by kind of holistic. Another thing that I see is, with an estate plan, people think, okay, my estate plan, my attorney is on the job for my estate plan, but they don't think about assets or asset titling in the context of that estate plan. So I've encountered situations where, young person has a large life insurance policy. They're not married. They name their mother as the beneficiary. Later on, they get married. They continue to pay the premiums on the policy, but they don't update the beneficiary to their spouse. And so now they're in a situation where they pass away unexpectedly. The largest asset of their estate is not passing to their spouse, it's passing to their mother. And that's just not really helpful. So it's that asset focus. And the last one I want to just mention briefly is, when I was actually talking with my father about his estate plan and his estate, and was looking at one of his assets and thinking, oh, this asset is more trouble than it's worth, I guess I would say, or what I call dead assets. The biggest one, if you want to strike fear in the heart of an estate settlement professional, you just need to say the word timeshare. Because timeshares are the quintessential dead asset.
That's right.
Nobody wants to buy them. You need to get them valued upon somebody's death, and nobody wants to receive them either. And so looking for assets like that, again, it's not really something that an estate planning attorney would typically do, is kind of go through your assets and tell you, you know what, these are more trouble than they're worth. But that's something that's really, really important.
Just to circle the square on something you mentioned, that beneficiary designation component is a vital thing. I've run into it all the time where people are named as beneficiaries in different accounts, now real estate, life insurance, all of that, and it hasn't lined up exactly with the way the will or the trusts are set up, and making sure that things are titled correctly. I'd go so far as to say it's worth it to check that every couple of years, just to make sure to make sure everything's sort of operating the way it's supposed to, and so that the legal documents are in alignment with those account documents, because you can really be saving yourself a big deal going forward. The other part I'd add on to that asset wise is, and I'm dealing with this front and center, is the tangible stuff. I think it's a good idea to have, at a minimum, a sort of list of wishes along with your documents saying who should get what within sort of, let's call it, the bulkier, interesting things within somebody's estate, so that you don't have people pointing fingers afterward and you're not left with a provision somewhere that says everything's divided into 3 parts, because sometimes that's just a lot of confusion.
Right. Yeah. No, those what we call tangible personal property. So, whether that's furniture, furnishings, mementos that might be in somebody's home, those are a constant source of problems. I'd say a couple of ways that they are. One is that somebody described this when I did a post on it a while back as probate by pickup truck, which is, if mom or dad passes away and all of the kids have access to the home, then when the executor steps in and they're sort of like, why is the home empty? Mom died 5 days ago and there's nothing left here. That's a problem, because maybe the person who was supposed to receive a specific item of property didn't get it. But B, as the executor, your job, to kind of go back to what I was saying initially, is to inventory and collect all of those assets, especially if it's an estate taxable situation. Now you've completely lost control of the narrative. You've completely lost, if there was a Renoir that's worth $5 million, you have no idea who has it. You have no way to appraise it. It's a huge problem. And I think, it's one of those situations where, we have to spend a lot more time focused on those types of things. Like you said, it is, here's who I want to receive these things. And you have to be specific. I've had a lot of situations where, you know, mom has 25 pieces of jewelry. I'm not an expert on jewelry. I don't know how this ring is different than this ring is different than this ring. We need to know very specifically how to distinguish where everything's located and who receives it. I think that's really vitally important.
So we're talking a little bit about the assets. Let's talk about the debts and expenses, because these are things that sometimes can be scary minefields when you look in the credit card statement or creditors start popping up.
Yes, no, that's really, really important. And one thing I would say is that it really is true, and some people don't believe this or haven't even thought about it. Is your debts survive your death? For the most part, they still have to be paid. And to go back to what we were saying before about how, where you've named different beneficiaries on all of your assets, you then pass away. Let's say that there's $100,000 in debt. How is it that the executor is going to pay off this very legitimate debt? They're going to have to bring everybody who received any assets from the estate into court. Anybody who is a beneficiary of any of those assets into court. And this is particularly a problem when you have an estate tax. So the estate tax is due 9 months after death. You can get an extension of the time to file. You do not get an extension of the time to pay, with very few exceptions. And so 9 months might seem like a really long time, but it isn't, especially if we're talking about an estate or a person who passed away owning a lot of illiquid assets. So that might be something like real estate or private equity, or I see it a lot with businesses. Somebody who owns a working business, maybe, we all know probably an NFL franchise, something like that. If you die as a decedent with, let's say, an estate of $100 million, all of your assets going to your children. Just to overly simplify, the estate tax on that $100 million estate would be about $40 million. How are you going to raise $40 million in 9 months? You can't do a fire sale. Are you going to take out a loan? Is there some other way of dealing with that? And again, what I would say is, just as we talked about taking a deep dive into how your assets are handled or titled, you really need someone to take a deep dive into, what are your debts? Let's understand all of them, including an estimate of what the taxes will be when you pass away. And then let's figure out how we're going to use those assets to pay those debts upon your passing. There needs to be what I would call a liquidity plan. There needs to be a plan to get those things paid for. And again, I call that person the quarterback, really, who's doing this analysis of both the assets and the debts. It can be your estate planning attorney if you want it to be. A lot of people would use their financial institution. When I was acting as a senior wealth strategist with BMO's family office, this is something that I would do. Not only are we projecting what your estate tax is going to be, but we're figuring out how that estate tax is going to be handled. You could also have, if you have a financial planner, if you have an accountant, the important thing is you need a quarterback. You need some advisor who has eyes on your entire situation and who really understands all those assets, all those liabilities.
So what do we do for the person who's named as the executor, and hopefully they're staffing themselves with the resources you just described if they aren't expert in it themselves? What can we do to help simplify the process for them and help them get organized?
I would say that, I'll talk a little bit more about communication here shortly, but I think making sure that they understand what they're stepping into. And I would almost encourage people, and some clients will do this. Some people will think, it's kind of strange, but like, they're really a partner. They should be sitting with you, maybe not in your estate planning attorney meetings, but they should really understand every year, let's say, and I think you mentioned this, let's do a refresh. Let's do an update every year, 2 years, 3 years. You know what? I've named you as my executor. To not get ahead of ourselves, are you willing to do that job? And let me explain to you what it is, and let's walk through that. But B, here's what I have. I want to make sure you understand all of these assets and kind of what the state of play is. That communication, I think, is really, really important. And I think you could even say not only who you've named as your first executor, but if you have a backup, maybe making sure that they're aware as well. It's really, to me, it's being transparent and it's communicating.
I couldn't agree more. And then, on top of that, it's just understanding that the people that you name, it's probably a good idea to make sure they're detail oriented, that if they don't have the exact expertise, that they know how to access it, really making sure that they understand who the players are, both from a beneficiary standpoint, but also the advisors around it, because you're getting thrown into a situation usually at maximum stress for the family, and it can wear on you very quickly. And it gets maybe to your next point, which is the importance of these personal relationships and how that interacts with each other.
Sure. And one point before I talk about that, what I always talk about is what I call a FIT test, FIT. And that is whoever you're selecting to be your fiduciary needs to have some sort of financial, I don't want to call it expertise, that might be going too far, but that's what the F stands for, which is you either know something about financial matters or you know enough to know that you don't. And that here's your accountant, here's my attorney, here's my financial advisor. So that's the F. I is, are you interested in doing this job? And then T is, do you have the time to do it? Because what I run into a lot is, you've got 3 kids and I'm naming my daughter as my executor. She's so bright. She's a doctor and she's got 3 small children. Can you believe she can juggle everything? And I just think to myself, I wouldn't wish that on my worst enemy. Or you have the person who maybe is not, the black sheep, or maybe they're not killing it out there in the world. And it's like, but they're very interested in doing this. They have the time. They don't know at all how to run an estate. So, but to kind of, move back, into that kind of ties into personal relationships and taking those into account when we're talking about both, I would say both beneficiaries and who you're choosing as your executor or your trustee. And this comes up a lot where we encounter situations where maybe people don't understand that when they pass away, how that passing is going to affect the relationships between their friends and their family members, especially family members, and how it might worsen those relationships, or maybe those relationships, frankly, aren't that good even during mom or dad's life. It comes up a lot where, especially in situations, but not specifically or not exclusively, situations where maybe you have 2 children and you are treating them differently under your estate plan, where maybe one of them gets 2/3 and one of them gets 1/3. And again, maybe that's completely fair in your mind. It's completely legal, but you're leaving a mess for both of those children.
There's no question. I mean, especially, the concept of dealing with people equally versus equitably. If you don't tell that story to them, and I have glibly putting it, getting some buy-in or at least some understanding, boy, you're really sowing the seeds for nuclear war going forward.
Yes, you really are. And what I always tell people, is a few different things. One is you need to be really clear-eyed about that. You need to understand and not sort of delude yourself into thinking that your kids get along with each other when they don't, or that your second, third, fourth, or fifth spouse doesn't get along with the kids from marriage 3 or marriage 1. And that's one of the reasons why, as part of what we do in Family Wealth, we really dig in with these family situations and talk with each generation as we talk about what we kind of call family dynamics. You can't assume that they're going to have good relationships after you're gone. And because in many cases, it's you being alive is the only thing that's forcing them to be civil, which is bad. But we talked about beneficiaries a moment ago, but the other part, like you said, is you can't create situations where you've got beneficiaries and then you've got the people who are running the estate, those executors, the trustee, the people who are carrying out your wishes. They don't get along, but you're either making them work together as co-executors or co-trustees. Or potentially even worse, you're saying, you know what, daughter, you've got your act together. I'm going to make you the trustee of the trust that I created for son, who's really struggling. And now when son needs money from his trust, he's going to come to his sister hat in hand and say, please, won't you give me some money for this, whatever I want to do. My band is putting together a demo, or I want to take a cruise around the world or whatever. Those are really difficult situations for all of those parties to deal with. And so, I think like you said, it's really the communication. It's telling your family what your plan is and it's explaining the rationale behind that plan. And to me, it's just vitally important. And I know it's a difficult conversation, especially if you are leaving different things to different people. But I can give you a couple of examples that I've encountered. One is you've got a family business. One of your children is really involved in the business and has helped you grow the business. One of them is not. If you want to leave the business to the child who's very involved, that makes perfect sense. But the one who's not involved may not see it that way, and it's going to cause a lot of stress between the two of them. The other one is you've got a child who's an investment banker who's, really, really wealthy. You've got another child who is a social worker, a public school teacher, not making a ton of money, and you want to leave more to that child who needs the money more, who's in an important profession, but you know what? They don't have that kind of wealth. You can do that, but you're really setting things up if you don't explain it and explain the rationale behind it and really articulate the reasoning, and sometimes you see people say it in documents where you'll say, I'm not leaving anything to this child, not because of a lack of affection, but because, I've made gifts to them in the past, or they're already doing fine. And I think, well, that's nice, but it would be nicer to hear that during life from a person face to face rather than reading it in your father's will when he's passed away.
No question about it. Articulating the why of the estate plan in a document, yes. A, it's rife with potential misinterpretation. B, that document is being read against the backdrop of decades of emotional baggage that have built up over time that we know or don't know of. And C, it gets back to that communication part that you really stressed, which I think is important, which is you're not going to really understand the technical aspects of it if you don't understand the emotional why behind it as well. And I couldn't agree more with what you're talking about. So as we segue into that component, maybe talk a little bit about how the actual estate plan, maybe the technicals, fit into this scenario.
Sure. And I work a lot with wealthy clients, and I work a lot with really, really good estate planning attorneys. So I rarely encounter, I won't say never, but I rarely encounter situations where, somebody tries to give away 105% of their assets or something like that. Usually that's not what we're getting into. More of what I encounter, I'm going to be careful how I say this. I don't want to unduly criticize, but there are people who do estate planning. And I think some of those people have never administered an estate. And so they haven't really thought through the logistics of how the plan is actually going to work. And in many of those cases, I might see people almost like being a scribe, where they are listening to the client explain what they want to have happen, incorporating that with legally binding language, but they haven't really thought about, does this work in a real sense? And I can give you a couple of examples. One is, this happened a few years ago. Dad, widower, I think the home is worth $2 or $3 million. He has a son and a daughter. The will gives the daughter the right to buy the home within 30 days of his death. And I read this and I think, well, on one level, that language works. I mean, it's able to be carried out. But two things. One is, does the daughter have more of a tie to that property than the son does? Because if they have the same tie to the property, or if the son even has more, attachment to the property, you're really setting up a dispute between the two of them. The other is, okay, there's a right to buy the home within 30 days. The home is worth $2 or $3 million. Does daughter have the ability to come up with that kind of cash immediately upon her father passing away? And I think in that case, the answer was no. And so we were able to, Dad was a little bit older, but we were able to have him redo his estate plan to make that provision a little bit clearer. The other one I encounter a lot is people setting up a trust that contains real estate, like let's say a home. I want to set up, I'm going to pass away. I want my sister to have the right to live in my home for the rest of her life. And then it passes to my son or my daughter. But they haven't said, are you giving any money to that account as well, to that trust account? Is it because there's the question of, is sister paying the taxes? Is she paying the expenses, the insurance? If she's not, where's that money coming from? How is the trustee, who has a duty to monitor trust assets and make sure that they aren't wasted, making sure that those debts are all paid so that when sister then subsequently passes, the property can pass on to whoever the next beneficiary is. So it's things like that where I'm very focused on, we really do need to read an estate planning document with an eye toward how is this going to work? If we go 5 or 10 or 20 years in the future, as a practical matter, just it's very pragmatic. It's not it's not the fun of we're creating some really complex gifting structure, but it's really, really important. I think you said it perfectly at the outset, which is it's really the rubber meets the road here, and making sure that estate plan works and doesn't have any of these, I would almost call them bugs, frankly.
It gets back in some ways to the concept of endowing certain things that you want to have happen. It's not just the asset itself. It's making sure you have the liquidity to pay for it. Whether it's making sure you have the money to pay for the taxes and so on around a house or a family compound, or whether it's a buy-sell agreement for a business so that, someone who passes away suddenly, the wife or the husband of that person who passed away isn't suddenly in business with the rest of the family. That can be disposed of as well. Having some quote unquote loose cash around to help get from A to B in that transition period can really save a lot of hassle on things. So we're coming toward the end. What are some quick takeaways here that you think are important for people as they think about their estate planning, not just from the I's dotted, T's crossed part, but the actual administration when it happens?
I think there are really two that I would focus on that I think kind of summarize what we've talked about here today. Number one is that tracking. You or someone you trust, a trusted advisor, needs to track your assets, all of your debts, and with an eye toward making things easy for whoever is going to be handling your estate. And that needs to be updated, if not every year, every 2, 3, 4, 5 years, so that's done. The second thing really is communicate, and have those discussions. And I know that it can be awkward. One of the things we do at Fifth Third is we have one of my colleagues in family wealth is an expert in family alignment or family governance, having those difficult discussions and helping to facilitate families having these discussions, because I think most people, we're around the holiday season. Most people do not think, okay, we're going to go for Christmas and dad's going to explain the estate plan, and we're all going to be fine with it. Most of us don't have that. I'm from the Midwest. We don't have those kinds of conversations here. And so having somebody who can help to facilitate it, if you can't do it yourself, is really important. But I think it is much as painful or uncomfortable as it may be to have those conversations during your lifetime. I think it's really meaningful, and B, it really moves the needle in terms of getting people to not create chaos upon your death where they didn't understand why mom or dad did this. They feel like somebody must have deceived them, or some maybe brother or sister took advantage. That communication, that transparency in your family, I think it solves, I don't want to say it solves every problem, but it makes this process so much easier when we're talking about estate settlement.
Just to add on to your comment on the tracking side of things and sort of that review every couple of years, I think it's a good idea to review the staffing of your estate plan in conjunction with those assets, making sure that the executor and any eventual trustees, that you still like them, that they're still alive, that they haven't had a stroke, that they haven't moved away, those types of things. I've seen it over and over again where, everything was sort of done and dusted and it's been in a drawer for 8 years. And then all of a sudden people go in and look and go, oh my gosh, we disassociated with them a while ago, that type of thing.
Right.
So,
right. I'm not friends with the person I named as trustee anymore.
Right.
The attorney that I named is now retired and living in Boca Raton. They're not interested in coming back to Chicago to administer my estate. Right. That's really, really important. And I think, and again, those are things where it's not necessarily a tax law change. It's a change in your personal situation. So, you may not understand the complexities of the marital deduction, but you certainly understand whether the people that you've named as executor are still in a position to act in that capacity.
Really good point. Joel, great stuff. How do we keep track of you? And A, thank you, but then B, let us know how we stay in touch.
Okay, definitely. Yes. I'm on LinkedIn. I'm going to try to be writing more in the new year. And you can reach me at joel.schoenmeyer@53.com.